After a long ping-pong game of courtroom hearings, banc rulings, remands, and disregard for the Bill of Rights going back to 2017, the Ninth Circuit Federal Court of Appeals has ruled 7-4 against the plaintiffs in a case called Duncan et al. V. Bonta, declaring it perfectly fine to threaten peaceful California residents if they own or try to get gun magazines that can hold more than 10 rounds. Hi everyone, I'm Gardner Goldsmith for MRC-TV, and yes, that's the latest. And as an added insult, California's dominant newspaper, the LA Times, offered this cozy, assumption-filled headline, quote, Ninth Circuit upholds California ban on large capacity ammunition magazines, end quote. Don't think about who defines large capacity or how, and forget that the possession of something isn't an aggressive act. Just bow in fealty to the Times and the majority on the Ninth Circuit Court. The backstory to this is important and starts in 1999 when Senate Bill 23, SB 23, introduced by Senator Don Parada, passed the California State Assembly and Senate, and then Governor Gray Davis signed it, making it illegal to manufacture, import, sell, give, or lend gun magazines capable of holding more than 10 rounds, though it allowed existing owners to keep them. A grandfather clause. How nice. Then in 2016, California passed Proposition 63, a statewide referendum that eliminated the exception for already established owners of the mags and increased the punishments for infraction. As Jonathan Turley notes, the case has gone up and down the court system since then. In June of 2016, District Judge Roger Benitez granted a preliminary injunction halting enforcement of Proposition 63's possession ban, which was set to take effect July 1st, 2017, and this was halted while the case proceeded. This allowed Californians to retain their so-called large capacity magazines that they legally owned prior to the ban. He soon issued a summary judgment in favor of the plaintiffs, declaring California's Penal Code Section 32310 unconstitutional under the Second Amendment and issuing a permanent injunction against its enforcement. And guess what? This stood for a single week, something Californians call Freedom Week, during which they could legally acquire large so-called capacity magazines. But following the California government's appeal, Judge Benitez stayed his own ruling pending appeal, reinstating the large capacity magazine ban, except for those who acquired magazines during that brief one-week window. Following its landmark decision in New York State Rifle and Pistol Association v. Bruen in June of 2022, the Supreme Court granted certiorari in Duncan v. Bonta and vacated the Ninth Circuit's 2021 en banc full court ruling and remanded the case back to the Ninth Circuit for reconsideration under the Bruen standard, which requires gun laws to align with so-called historical tradition rather than what gun grabbers call balancing the rights of people with the so-called public interest. Someone might want to tell those people that they morally and logically cannot determine for you what is a minimal burden, and they cannot claim that the interests of government take precedence over the God-given rights of individual human beings. And after a tremendous amount of back and forth, stays and reversals, we arrive at the March 20th Ninth Circuit en banc decision this year. As Turley writes, quote, in a 7-4 decision authored by Senior Circuit Judge Susan Graber, an appointee of former President Bill Clinton, the majority wrote that a large capacity magazine has little function in armed self-defense. but its use by mass shooters has exacerbated the harm of those horrific events. End quote. You know, heavy trucks can cause more harm to people when violent folks drive them into crowds also. Does that mean politicians have a right to take them away from peaceful people? And pay no heed to the explicit proscription of the Second Amendment banning all restrictions on the right to keep and bear arms, and forget the fact that the court is acting in a completely arbitrary manner when focusing on mass shootings as their so-called threshold for banning a certain size magazine. In fact, even on their level, the majority on the Ninth Circuit have a very flimsy argument. It doesn't take long to crunch the numbers at the Gun Violence Archive, GVA, for January through December 18th of 2024 and discover a few major facts that the large capacity magazine banners don't discuss. As of December 18th, 2024, GVA reported 16,088 gun-related deaths in the U.S., excluding suicides, and 31,652 injuries from homicides, murders, unintentional shootings, and defensive gun use incidents, totaling 47,740 victims of gun violence, resulting in homicide or injury. Mass shootings, defined by GVA as incidents where 4 or more people, excluding the shooter, are shot, number 491 by that date, with 500 deaths and 2,134 injuries, totaling 2,634 victims. Meaning that for all gun-related deaths and injuries, including defensive uses through December 18th of last year, mass shooting victims comprised 5.52%. This Ninth Circuit ruling defies logic, and it shows us how dedicated gun grabbers are in their quest to attack any facet of armed self-defense that they can attack. It will, of course, head to the U.S. Supreme Court, where Turley notes, quote, it will join another magazine ban case in Ocean State Tactical v. Neronha, which is awaiting a decision on whether it will be picked up by the court, end quote. And despite the 2022 Supreme Court Bruen decision affirming the right to personally carry firearms outside the home, the gun grabbers will attempt to define the gun magazine as an accessory that might not be covered by the Second Amendment. Well, you know, it shouldn't matter how they define what you want for your self-defense. Such an attack means government officials, backed by government guns, using government-collected tax money, are eager to argue in a government court, which of course you also have to fund, that you peacefully can't own something for your self-defense. And it clearly shows us which side of the government v. individual fight is actually engaging in the aggression. It's so clear. You want to be left alone, they take your money and they use it to continue attacking your right to self-defense. Amazing. Unbelievable. Well, perhaps some younger people will be able to see this video and they'll see the stark difference between aggression and defense. Thanks for watching, everyone. Please like and subscribe. Find us at Rumble, where they don't censor MRC TV. We are still on YouTube, where, yes, they engage in censorship big time. And, of course, you can find us all the time inside Facebook and at MRCTV.org. That's MRCTV.org. Check out what the whole team is doing, visit the store, and please consider donating to the Media Research Center. You can also find us on TikTok, on Instagram, on X, and if you want to find me on Gab, I'm at Gardner Goldsmith on Gab, and on X, you can find me as at Gard Goldsmith. Thanks for watching, and please share the videos far and wide. For MRC TV, I'm Gardner Goldsmith.